Hello everybody. Today we'll be talking about Indian Partnership Act of 1932. It's one of the oldest and very famous act. Definition of Indian Partnership Act under Section 4 gives partnership as a relationship between persons who have agreed to share the profits of a business carried on by all or any one of them acting for all. So in a partnership, the definition itself will give us a clear understanding as to it is a relationship between two or more persons who agree to share their profits in a predetermined manner. The business might be carried on by one or all of them who act for all of them. The persons who enter into relationship are basically called as partners. The essential elements of a partnership can be seen as it is the association of two or more persons. As we mentioned, the minimum number is 2, maximum limit is 10 for banking, 20 for other businesses. Only competent persons can enter into business. It might be an artificial person or it can be a natural person. It is the second criterion, it is a result of an agreement. So partnership is a relationship based on contract. It can be implied or an expressed relationship. It does not give rise from an operational law or inheritance. That is, it does not give rise to any law of inheritance, which means if my father had a share, I does not automatically become the shareholder of a partnership firm. I have to enter into the business again back with the consent of all the existing partners, then only I get the shares, but profits can be shared. Must carry on some business. It might be on trade, occupation or profession must be carried on in the partnership. Share profits of the business. Business is carried on by all of them, by all, that is all the partners are active partners, they take part in the business, or it might be any one of them who was a working partner who goes. That is, there is a mutual agency between all of them. Every partner is an agent and a principal for himself who are responsible each other and themselves. Utmost good faith, which is one of the important principle on which the partnership stands, that is, they act just and faithful to each other. The other important characteristic which differs partnership from a company is unlimited liability which it holds. It is joint as well as unlimited. That is, in case when the partnerships or the partnership firms assets are not sufficient enough to pay off the debts of a third party, the partners' estates can be confiscated to pay off the third party debt. There is no separate legal existence. There is no separate legal existence between a partner and a partnership firm. Or the firm and the partner is not different. They act for the firm. Partner works. But whereas in a company we found a company has a legal existence which the company and its members are different. Restriction on transfer of shares, that is, it can be done. You cannot freely transfer, whereas in a company free transfer of shares was possible, whereas in partnership free transfer of shares is not possible. It can be done only with a permission of all the existing or the consent of all the partners have to be given out for such act. Next topic is mode of creation of partnership. So how do you create a partnership? As we have already said, it is based on an agreement. An agreement may be expressed or implied in writing. It is helpful in times of adversity. So most of us prefer to have it in writing rather than a verbal one, and those deed in which we write is what you call, or the terms and condition of a partnership, if written, you call it as a partnership deed. The essence of partnership, as we already mentioned, is the trust and confidence which each partners have between themselves. It has to be drafted with care and signed by all the partners. It is to be stamped according to the Indian Stamp Act. The firm should be registered and copy of the deed has to be filed with the registrar of companies. That's a procedure for creating a partnership. Let's see what are the different types of partnership. First one is partnership at will. No provision in contract between the partners for the duration of partnership. Determination of partnership is also not there. If any partner gives notice for dissolution in writing, the partnership stands dissolved. That is, there is nobody has said that there will be a particular duration for a particular object or adventure. We are not coming into partnership. There is nothing regarding the duration of partnership or the determination of partnership. It can be till it goes. Particular partnership, a person may become a partner with another person in particular adventures or undertaking. On completion of such ventures, the partnership comes to an end. As with regard to partnership at will, this particular partnership, the basic difference is that in this, partners or a group of persons come together, they form a partnership and for a specific work or adventure to take it. Once the project is over, they disseminate. That is the speciality of particular partnership. Partnership for a fixed term. In this, duration is fixed, that is only for a particular period of time they remain as partners. Partnerships come to an end when the term expires. If partners continue the business after the fixed, it becomes partnership at will, because for partnership at will there is no restrained time duration is not specified.